detention of children of asylum seekers. And the family court, judge at first instance, majority in the full court, had held that the family law, that the Migration Act 1958 did not apply to children. It only applied to adults, and you can detain adults but not children. And I was naturally very sympathetic to such a view, because that would bring us back into conformity with the International Child Abduction, the International Convention on the Rights of the Child. But when I had to analyse the case, there were two icebergs which approached me like the icebergs in the Titanic. One of them was that it was proved by Solicitor General for the Commonwealth that the fact that this decision supported the imprisonment of children in detention was specifically drawn to the notice of Parliament, that would probably make us in breach of the Convention on the Rights of the Child. To their great credit, the officials of the Attorney General's Department rushed over to Parliament, told the Minister, Mr. Hand, the Labor Minister, they told him, this, if you enact this, this will be in breach. And that was tabled, and it was in Parliament, and they said, hang it, you know, we've got our own right, this is Australia. And secondly, there were provisions in the Migration Act 1958 that allowed for searching of children in detention. And if the children were ex hypothesis not to be in detention, you wouldn't have needed the provision for their searching. So the searching made it clear that where it said any person who does not have a visa shall be detained, the person included a child person, because Parliament had expressly signalled that it was applying to children by allowing for searching. Now that wasn't a very comfortable decision for me to reach, but it was a decision I felt I had to reach, and so the court was unanimous in that case. I mean, I will apply the law, but I'll apply the law and get my spectacles, put them on, and wow, I'm seeing the law in an international context, which in the age of the jumbo jet and of the internet and of all the other paraphernalia of the world we live in is not such a weird notion. I have no doubt, this is going to sound a little bit vain and that's so uncharacteristic of me, I have no doubt that if one thing of what I did lasts, it will be the references to international law and international human rights law. Because that's just the way the world is going, the way the world operates today. You can't just, we're not now a colony of a white Anglo-Saxon empire. We're a country, a multicultural country, in a very interesting region and part of the world. And that's how law in the future will be seen. In your lifetime, definitely, yes.
I just wanted to ask, how do you feel we can reconcile the different standards that each country has and the state's sovereignty, so how we can reconcile the different standards in terms of human rights and the state sovereignty involved with those standards, how we can reconcile our differences, say in Australia, with, say, countries like South America where there's high instances of domestic violence. When you're dealing with particularly very private issues, taking care of the child.
Well, you can reconcile it because we all have to live together and we all trade together and we all communicate on the internet, unless we're North Korea, together, and therefore reconciliation is happening every minute of every second of every day, and it's happening at an astonishing pace. So I don't find that all that difficult. How do you reconcile sovereignty? Well, you reconcile sovereignty by reading sovereignty down. This is what North Korea said after the report of the Commission of Inquiry, which we published in March. They said, we are going to publish our own report on our own human rights. and it will be a rosy report, they said. Well, it sure was. It's about 90 pages long, and they are the only country still that ever came to the Human Rights Council and said, you've made 187 suggestions for improvement about human rights, we don't accept one. In fairness, as a result of the global response to the Commission Inquiry report, they have now evolved their position in order to accept some of the recommendations, and they're now in dialogue about more recommendations. And the Supreme Leader has fallen very, very sick. So that things have started to happen, and that's how it's expected to be. I mean, you can't have a country saying, well, we're sovereign, we're going to join the United Nations, but we are entitled to do what we want. Well, you can't. Once you start joining international treaties, you bind yourself. Once you join the Charter of the United Nations, you bind yourself. Your sovereignty is diminished to the extent of your international obligations. Now, some people don't like to say that, and I've even been told, don't say that in the United States of America, because they don't like to hear that at all, that the sovereignty of the United States is reduced by engaging with the United Nations. But that's just plain lawyering. If you join the international community and you sign up to the Charter, and the Charter has an organisational structure with the General Assembly and the Human Rights Council and the Security Council, and the Security Council has the special voting rights of the Permanent Five, then you can't give a special veto to every country, because specifically you've given it only to the Permanent Five, and then only on matters of international peace and security. So that sovereignty in the 19th century notion doesn't work today. It doesn't work because of global epidemics like Ebola and AIDS, and it doesn't work because of terrible weapons like nuclear weapons and chemical weapons, and it doesn't work because of tremendous advances in technology like jumbo jets and the internet. And therefore we have to, and the world, whatever lawyers say, the world will continue to evolve to live together and to harmonise as far as we can. That means an impingement upon sovereignty. Yes?
My question is about the comments made by Justice Gunnar in the Israel case, where he seems to, he expresses concern about sending a child back to countries where the mother and the father would be on unequal footing in a custody dispute in front of the courts. Do you think that given that Australia doesn't have to accept every country, reciprocity to every country as in the convention, and that's done by people with considerable expertise, that it's ever really appropriate for the judiciary to inquire into the judicial systems of other countries? Did that make sense?
The answer is, I understand the question, it's a good question,
yeah.
But I think that question should really be considered by the executive government under the law that is made at the time of deciding whether, having ratified the International Child Convention, we want to ratify it for reciprocity with X. Say Egypt, say Lebanon. Australia has not, Lebanon is a party to the convention, but although we have quite a big community of Lebanese people in Australia, we have not accepted Lebanon as a country with which we will have reciprocity. So it does happen, and I think that's a better way. There's also, outside the pure law here, there is an informal system, and I think I referred to it in one of my decisions, within the Family Court of Australia and family courts around the world, that they appoint a person who will be a sort of liaison judge. And so there is a judge who specialises in international child abduction, and that judge was Justice Kay, who was one of the judges in one of the cases, the Israel case, I think. But so that often, whatever the arrangements, they will talk to their counterpart and build up a relationship with the counterpart judges in many other countries, because Australia's a big user of this, given that we have so many migrant populations. I mean, in Japan, they won't even allow third generation Korean Japanese to become citizens. Don't tell me that the only racists in the world are Anglo-Celts. It's not true. Every country has racism. And, but we've tried to suppress ours. We're not doing such a good job if you look at daily newspapers at the moment. but we've got a lot of people from a lot of countries, a lot of young people from countries who are having children and who are therefore likely to be in the clientele of the International Child Abduction Convention. And therefore we've got to be very practical and sensible about our